Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. I'm a Massachusetts business lawyer with over 15 years of experience helping entrepreneurs buy and sell businesses. Imagine that you found a business that you might want to buy. From the outside, it looks perfect. It's in the right area, it fits your skill set, and you think that you can grow the business and make a lot of money. So you want to see the books and learn more about the customers, the profitability of the business, and how the business makes money. But before the seller or the seller's broker will hand you over any financial information about the business, they send you a non-disclosure agreement, which is also called an NDA. Now, it's tempting to just glance at it, assume that it's just standard boilerplate and doesn't matter, and just sign it so that you can get the information that you want to see in order to evaluate the business. This could be a big mistake. The heart of an NDA is the definition of confidential information. This definition decides what types of information needs to be protected, can be talked about with others, or has to be returned to the seller if the deal falls through. If you misread the definition or don't fully understand it, you could find yourself in hot water years after the deal closes or falls apart. In this video, I'll walk you through 5 critical legal secrets hidden inside the confidential information clause. These aren't textbook theories, but they are practical, real-world tips to keep in mind when reviewing an NDA to get you the information you need to evaluate the business and also to save yourself from potential liability in the future. And please, if you'd like to get more helpful legal tips, please hit the like and subscribe button below. It really helps the channel and lets me know that you'd like to receive more helpful legal tips like this one. So let's get to it. Secret number 1, the overly broad definition trap. The first secret, which should not come as a surprise to anybody, is that the seller's lawyer, or more likely the seller's broker, who wrote the NDA that you've been presented with, wrote the NDA to protect the seller and not you. This might seem obvious, but you need to recognize the full ramifications of this point. Their goal is to provide maximum and broad protection for the seller and the seller's information. Because of this, they'll define the term confidential information as broadly as possible, using phrases like, quote, any and all information in any form related to the business, end quote. Now, at first glance, this might seem like a reasonable definition. But for you, the buyer, this broad definition is potentially a trap and can pose all sorts of problems. When the definition is too broad, it can include all sorts of information that shouldn't be treated as confidential information, such as publicly available information or information that you already know from your background knowledge or already being in the industry. The biggest danger for the potential buyer is that you could violate the NDA without even meaning to. For example, imagine that you're in the same business industry as the seller. During your due diligence, you learn that the seller uses a particular supplier, call it Company X, the seller considers to be its most important and most critical supplier. You've known about Company X for years and have used them in the past, although the seller doesn't know that. 6 months later, the deal is dead after you decide not to buy the seller's company. However, you call on Company X to provide you with supplies for your business, and unfortunately in doing so, Company X is no longer able to provide the same level of goods to the seller without a significant delay. If this happens, the seller might try to sue you and claim that you misused and misappropriated their confidential information when you learned about Company X. You may or may not have a defense depending on the NDA you signed. But either way, proving you knew it beforehand can be a costly and expensive legal battle that no one wants to be in. The solution here is to negotiate a precise definition of confidential information in the NDA. Most buyers think they can't negotiate over the terms of an NDA, but that's not true. An overly broad definition of confidential information in an NDA has risks for the seller too, as these overly broad definitions may not be enforceable under applicable law in Massachusetts or elsewhere. However, as the buyer, you definitely should not accept a definition of confidential information in an NDA that states that, quote, all information related to the business, end quote, is confidential. Instead, as I discussed in my earlier 8 NDA secrets video, a well-drafted NDA should identify the specific categories of information that are being protected. I'll put a link to the video below. This will include things like financial statements, business plans, trade secrets, proprietary technology, and so on and so forth. Of course, you won't know everything that the seller wants to protect, So you'll need to negotiate this with the seller to include the right types of information to be protected as confidential information. This will create clear boundaries, protecting what's truly sensitive and worth protecting from the seller's perspective, while also stopping the seller from claiming they own general industry knowledge or anything in connection with their business. Having a narrowly tailored definition of confidential information is your first line of defense to making sure that the NDA doesn't come back to bite you if the deal breaks down. Secret number 2, the marking myth. Secret number 2 tackles a dangerous myth. The idea that only documents physically stamped or marked with the word confidential information are the information that's actually protected by the NDA. A lot of people believe this, and some buyers even go so far as to try to negotiate this requirement into an NDA. From the buyer's perspective, it's a great requirement and creates a clean and simple system for the buyer. If a document's not marked as confidential, it's not confidential information and doesn't need to be protected from disclosure and doesn't need to be returned to the seller if the deal breaks down. But in the real world of an M&A deal, it's just not feasible for a seller to label every single document and email that contains confidential information as confidential. More importantly, some of the most valuable information you'll want to receive in order to evaluate a business won't be contained in a document or an email at all. It will be shared in conversations with the seller's owners, its employees, or its representatives. Think about a site visit where a manager explains a unique manufacturing project, or a call where a sales director lays out a pricing strategy for its top clients. None of this information can be marked as confidential, but it's incredibly invaluable information that you'll want to receive. Sellers' lawyers know this. They will insist that the NDA's definition of confidential information covers information in any form, oral, written, electronic, or otherwise. They will push back hard on any requirement that the seller's confidential information is only limited to documents that are marked or stamped as confidential. And even if they agree to it, you likely won't be able to get all the information you want or need in order to properly evaluate whether to buy a business or not. The problem for the buyer is that if you sign an NDA with a definition of confidential information that allows for information to come in, quote, any form, the responsibility is on you to try and determine whether every casual chat contains seller's confidential information. And if it does contain confidential information, you must treat the conversation with the same care as if it was contained in a formal report that was stamped as confidential. This can be a real pain. The way to solve this problem is to establish a process in the NDA for handling oral disclosures that contain the seller's confidential information. A common and fair approach is to add a clause in the NDA that says if a seller shares confidential information with you orally, they have to follow up with a written summary within a set period of time, usually 10 to 15 days, confirming that the information that was disclosed orally was actually confidential information. This is a win-win solution. For you, the buyer, it gets rid of guesswork about what's actually confidential and what isn't. You're not on the hook for every off-the-cuff remark or random conversation between the parties. If you don't get a written summary from the seller, the information you received orally isn't confidential information protected by the NDA. For the seller, it forces them to be disciplined about what information is really confidential information as opposed to just general business talk that's not confidential. It also strengthens the seller's case for any potential lawsuit over misappropriation, as they have a paper trail notifying you that certain information is considered confidential and should be protected by the NDA. However, no matter what NDA you sign as a potential buyer, you should never assume that only documents marked confidential are the only information protected by the NDA. Instead, push for a process to confirm oral disclosures in writing in order to be clear about what information is actually the seller's confidential information. Secret number 3, the crucial carve-outs. Secret number 3 is your main defensive tool as a buyer in connection with an NDA. As I discussed in my 8 NDA secrets video, the definition of confidential information in an NDA is just as much about what it excludes as what it includes. So, as part of the definition of confidential information in an NDA, the NDA should also explicitly state what types of information are specifically excluded from being considered as confidential information. These exclusions are also known as carve-outs. Now, the first draft of the NDA you receive from the seller or the seller's broker might have weak carve-outs or no carve-outs at all. If that's the case, you or your lawyer need to push hard for 4 standard carve-outs that are essential in every NDA for a business acquisition. These essential carve-outs are non-negotiable, and you should always insist on them on any NDA you are presented with. The first essential carve-out is that any information that you already have before signing the NDA should not be considered as confidential information. This is critical. If you've been working in the industry for years, you already have a wealth of existing background knowledge. And this carve-out makes it clear that the seller can't claim confidentiality or ownership over any information that you already possess before you sign the NDA. One potential issue in connection with this carve-out is if the seller has already provided information to you before you sign the NDA. As a general rule, this information should not be considered confidential information under the NDA, but sellers will often try to make up for prior disclosures by retroactively claiming that this information should be treated as confidential. Don't fall for this. The fact that the seller disclosed certain information to you before you signed an NDA counts as strong evidence that the previously disclosed information is not confidential information, and you should be allowed to do with it whatever you want to do. The second essential carve-out for an NDA is that any seller's information that is or becomes publicly available should not be considered confidential information so long as you or your employees or representatives were not the ones who made it publicly available. For example, if a trade magazine writes an article about the seller's new business strategy, that business strategy is no longer confidential even if the seller had previously disclosed it to you and marked it as confidential when it was disclosed to you. You can't be held responsible for relying on or using information that becomes publicly available through no fault of your own. Keep in mind, though, that if the party who publicly disclosed the information is related to you in any fashion or did not have permission to publicly disclose it, this carve-out may not be applicable. It will all depend on the specific language of the carve-out in the NDA and how it is drafted. So, you will need to be careful before relying on this carve-out if the circumstances of the public disclosure are in any way suspect or related to you. The third essential carve-out for an NDA with the seller is that any information that you got from a third party who was legally allowed to share it with you should not be considered confidential information under the NDA. For example, if a mutual supplier tells you that the seller just placed a huge order, that information is not considered confidential information under the NDA since you learned about it from the supplier. Keep in mind, though, that if the supplier is under an obligation of confidentiality to the seller, this information might still be considered confidential information under the NDA because the supplier was not supposed to share it with you. This carve-out to the NDA only applies to information that you legitimately received from a third party who was allowed to share it with you. So, if the third party stole the information or is breaching an NDA with the seller, the information is still considered confidential information under your NDA. The fourth essential carve-out for the NDA with a seller is that any information you develop on your own without using or relying on the seller's confidential information should not be considered confidential information under the NDA. Your own company's research and development doesn't just stop because of a potential transaction with the seller. This carve-out protects your company's own internal innovations and inventions so that the seller can't later claim that your new products came from their confidential information. Keeping good records here is key. Also, to the extent feasible, you also shouldn't share seller's confidential information with any member of your R&D team that is responsible for developing new products in your company. These four carve-outs are not small details. They are the safety valves that make sure that the NDA is fair, reasonable, and based in business reality. You must make sure that any NDA you sign contains them so that your business is protected. Secret number 4, the Residuals clause. Secret number 4 covers one of the most debated provisions in an M&A non-disclosure agreement, the Residuals clause. While not widely known, Residuals clauses are becoming much more common in non-disclosure agreements for M&A transactions, especially among private equity firms and big corporate buyers. A Residuals clause answers a key question. Is the buyer allowed to use or disclose any of seller's confidential information that remains in the unaided memory of the buyer's employees or agents after their exposure to the seller's confidential information? After your team spends months digging into the seller's company, they can't just forget all of the seller's confidential information if the deal falls through. They will likely remember general concepts, know-how, strategic ideas, methods, and other high-level takeaways. A typical residuals clause allows the buyer's team to disclose or use any of the seller's confidential information that remains in their unaided memory without violating the NDA, so long as they didn't intentionally memorize specific data in order to steal it. For you, the buyer, this clause can be critical, as it is very difficult to separate information learned in connection with a particular acquisition from information that was previously known or learned about by the members of your deal team. For example, if you're considering buying a software company, your deal team might learn about the seller's software code and also its general methods of structuring software algorithms. The former is unlikely to be remembered by anyone, especially in their unaided memory. But the general methods are something that could be supplementing your deal team's pre-existing background knowledge and could be remembered and applied in the future when evaluating other potential acquisitions by the buyer or in their general business operations. Without the residuals clause, the seller could come back later and claim that any future business decision you make regarding software companies was unfairly influenced by their confidential information. If you're a company that's looking at purchasing multiple companies in the same industry, a missing residuals clause could severely impact your ability to operate going forward. This clause lets your deal team use their professional knowledge and experience without the constant threat of a lawsuit. Sellers, on the other hand, usually hate residuals clauses. They basically see them as a major loophole in the NDA that gives the buyer a license to disclose and use their confidential information and trade secrets. They'll argue that it's impossible to tell the difference between unaided memory and deliberately memorizing secret data. For this reason, you can be sure that the seller's first draft of the NDA will almost never include a residuals clause. The negotiation over this clause is where having an experienced business lawyer really pays off. A common compromise is to define the clause very carefully. The seller will want to add language to make it clear that it doesn't give the buyer a license to use their patents, copyrights, or other specific intellectual property. The seller will also want to ensure that any residuals clause in the NDA does not undermine the prohibitions in the NDA on disclosure of sellers' confidential information to third parties. They might also try to include highly sensitive data like specific customer lists or software source code. Depending on the exact language, any of these proposals for a residuals clause can be acceptable. And just having the clause in the NDA is the vital first step for the buyer. It's an essential part of your long-term freedom to purchase multiple businesses in the same industry and have the same deal team evaluate these multiple businesses. Secret number 5, ancillary restrictions and disguise clauses. The final secret is that the definition of confidential information in an NDA often doesn't exist in a bubble. It often acts as an excuse for trying to include other restrictive clauses in the NDA that have nothing to do with just keeping confidential information quiet. The most common one is a non-solicitation provision. Here's how it works. When you review the seller's confidential information in due diligence, you're likely going to see lists of their key employees and top customers. Usually, if you're in the same industry as the seller, one of the seller's biggest concerns is that you're not really interested in buying the company, but are just using due diligence as a Trojan horse to learn information about their key employees and their biggest clients so that you can poach them. To try and prevent this, the seller will often include a non-solicitation clause in the NDA. As I discussed in an earlier video, there are 2 types of non-solicitation clauses. The first type is a client or customer non-solicitation, which restricts the buyer from trying to solicit business from the seller's clients or customers for a certain period of time, usually 1 to 2 years. The second type of non-solicitation clause, often called an anti-rating clause, restricts the buyer from trying to hire away the seller's employees for a period of time, usually 1 to 2 years. I won't go into detail about these clauses since I discussed them in an earlier video. I'll put a link to the video below. As a general rule of thumb, however, a buyer should reject any attempt to include any kind of non-solicitation clause in the NDA. In a typical NDA, the buyer will already be prohibited from using the seller's confidential information for any other purpose other than deciding whether to acquire the seller. So, if the buyer uses the seller's confidential information to try and steal the seller's clients or employees, the buyer will already be breaching the NDA and there is no need for a non-solicitation clause. Additionally, to the extent that buyer and seller are potential competitors, a non-solicitation clause in an NDA will unfairly restrict the buyer's future activities. After all, even if seller does not disclose the identity of its customers and employees to buyer, the buyer may want to target them as part of its normal business activities. So, a non-solicitation clause will stop the buyer from operating its business in its normal, profitable way. This is a heavy price for a buyer to pay for exploring the possibility of acquiring a seller. However, if the seller insists on including a non-solicitation clause as part of the NDA, you should negotiate very carefully for a narrowly drafted provision that is limited in both duration and scope. An overly broad clause might prevent the buyer from hiring any of seller's employees or doing business with any of seller's clients, even if one applies to a public job posting on your website or seeks business from you without any prompting. I advise you to speak with a knowledgeable attorney if you need help drafting an appropriate non-solicitation clause as part of your NDA. So let's recap the 5 secrets. First, reject the overly broad definition of confidential information. Push for specific categories of information to be identified as confidential information. Second, don't fall for the marking myth. The most valuable information in an M&A transaction is often shared verbally. So make sure to put a process in place in the NDA where confidential information disclosed orally needs to be confirmed by the seller. Third, fight for the 4 essential carve-outs from confidential information. They are non-negotiable provisions that protect your business. Fourth, get a residuals clause in your NDA. This memory loophole provision protects your team's ability to use their professional judgment and their background knowledge down the road. And fifth, spot the hidden restrictions in an NDA. Non-solicitation clauses don't belong in an NDA and can seriously hamstring your business. In conclusion, the term confidential information seems simple, but it is the engine that drives the entire NDA. Ignoring its importance creates significant legal risk and can have serious financial fallout. A well-drafted NDA isn't about creating unfair rules, but creates clarity and balances the seller's need for protection with the buyer's need to conduct due diligence about the business. My final piece of advice is this: never treat an NDA as a standard document to be signed without a second thought. It is the first real negotiation of the deal and sets the tone for everything that follows. By negotiating the NDA, you're not just being difficult. You're simply showing the seller that you are a serious, well-advised buyer who's protecting your business from future lawsuits and setting the stage for a successful acquisition. If you find this information helpful, please like, subscribe, and share it with another business owner. And as always, thank you so much for watching Small Business Legal Tips, and I'll see you next time.